or exclude the recordal and disclosure of some information on, say, 10 Rand contributions or the cleaning of offices or premises for free by one or more people. It is arguably an incredibly tedious exercise to have to record and disclose every quantifiable assistance or support given to a political party or independent candidate, however negligible. So the standard that they set is that if Parliament, we are not excluding the possibility. Yes, this is the requirement. Full disclosure, full recording and full disclosure. We're not excluding the possibility that negligible contributions might be something that yes, that negligible contributions could be something that Parliament could justify excluding. But the onus is on them to prove it. And in our case, milady, what we have is a situation where, as the legislation stands now, all contributions have to be recorded, and that information has to be held under the current legislation, under the PPFA, because this comes from the very structure of PPFA. The structure of the PPFA, according to the respondents, they don't take issue with it. In fact, they say so. Says that there's an annual threshold of 100,000 Rand and an annual limit of 15 million. And therefore, you can never know on day one, on April the 2nd, when you get a donation of 100 Rand, whether that will breach the threshold or breach the upper limit. And therefore, you must record it. All of that is recorded. And in fact, we know from the legislation, all donations must be reported to the IEC. So the only thing we are really talking about is whether there should be disclosure of those recorded donations. They must record they must record their details, otherwise they wouldn't know whether they've contributed 100,000 in the financial year. They won't know. They won't know whether they've contributed 15 million in the financial year. So they must record everything already. And there's deathly silence from the respondents on that score, because it is absolutely fatal to their case. So milady, in this particular case, the Constitutional Court by no means gave a discretion to Parliament to set a limit of 100,000 Rand. What it talked about was certain negligible contributions that you might want to exclude. And milady, in relation to the Political Party Funding Act as it stands currently, some of those negligible contributions are excluded when you read donations, the definition of donations in kind. It says it includes donation in kind, which is donations which are not monetary in character, but can be given some value. And they say, yes.
In Accounts 2, the threshold and the limitation was not an issue before the Constitutional Court. In fact, it was a different legislation that was being challenged in the Constitutional Court. So, could the Constitutional Court even consider a limitation or Parliament's obligation in respect of a threshold or a limitation? And if it wasn't before them during my vote counts too, should Parliament not be allowed the space to deal with this aspect before the court imposes a threshold? Because if we do that at this stage, how does it impact on the doctrine of separation of powers?
Yes. Milady, in the current circumstances, it's correct to say my vote counts to did not have any thresholds or upper limits before it. That was not the case that was made out. There was no legislation. The only legislation was PIRE. And PIRE did not provide for access to this information at all. What the Constitutional Court was made findings on is whether the Constitution requires the orderly disclosure of all, first of all, the record keeping, and that's very important, and then the disclosure of information about funding, private funding. It held comprehensively that the Constitution imposes that obligation. And it also held comprehensively that it imposes that obligation in respect of all donations, all contributions. There's no doubt about that, and I'll take this court to the findings of my vote counts to, which cannot be clearer in that regard. But what it also held, so whilst it held that there has to be a recording and reasonable reasonable accessibility of that information, it didn't deal, of course, specifically with any upper limits were not even subject matter of that case, and therefore it's not. There's inspiration that we draw from it and finding, but wasn't the subject matter of the case. On the disclosure threshold, our submission is that, of course, it wasn't before them, but on the findings that they made, it is very clear that what Parliament did now is contrary to My Vote Counts 2. And that's the case we bring. But we don't only rely on My Vote Counts 2. We rely on the constitutional rights that form the bedrock of what My Vote Counts 2 considered, and other constitutional entitlements. And that's our case. And our case on threshold is that there was procedural irrationality. There was substantive irrationality. So firstly, Parliament didn't do any research. It did nothing. It did not consider any of these comparative jurisdictions. I'm not saying comparative jurisdictions are actually relevant. It did not consider the socioeconomic circumstances in South Africa. But most importantly, it didn't consider what kind of amounts would sway our political process in an unacceptable fashion. And that's really at the core of what My Vote Counts 2 was about, and My Vote Counts 1, for that matter. That is...
This is not a review. In a review, we would know what information was before Parliament when they decided upon the limitation and the threshold. We would know exactly what information was before them, what factors they took into account. Because this is not a review, we have the applicant's paper saying they took nothing into account. But we don't know what they did take into account. You are the applicant, you need to tell us. We asked for information, nothing came to hand, therefore they didn't take anything into account. But as the papers stand, there's an assumption that Parliament took no factors into account. How do we know that to be the case?
Yes, Milady, this is a challenge, a constitutional invalidity challenge,
yes,
and we are entitled to pursue it under Rule 6. It is a review of sorts. It's a constitutional review. It's a review of legislation. The court does not have the record, but it does have the allegations. My Vote Counts, the organization, was principally involved in the legislative process. They participated, they made submissions, they know firsthand what was and wasn't taken into account. We've made allegations in relation to the fact that these aspects were not taken into account. The respondents don't suggest that anything was taken into account. They don't suggest that any of the comparative factors, jurisdictions, or any of that form the basis of their calculation at all. There is no such allegation. They simply, on an ex post facto basis, now try to come up with reasons why
So is it the applicant's case
yes.
that we should then accept? Because the respondents do not respond to the allegation that no factors were taken into account, that we should accept that Parliament took no factors into account, and that the threshold and limitation was set arbitrarily.
Yes, absolutely. Milady, there's no doubt that it was arbitrary. What they now try to suggest is they cherry pick, and this isn't even the executive, this is the DA. They try to cherry pick a few jurisdictions, and they say, well, if you squinted it enough, you can see there's a Milky Way of some sort of a middle way between upper limits in some jurisdictions and upper limits in others, and between thresholds in some jurisdictions and others, and we are within that realm, and therefore it was reasonable for Parliament to decide to impose those limits. But that is absolutely not correct. And we know from the legislation, even the impugned legislation, the PPFA, as it currently sets out, it doesn't even set out comparative jurisdictions as one of the factors that needs to be taken into account. it sets out other factors. And those factors, we say those factors are incomplete, but there's no evidence that any of those factors were taken into account. There was no research done. They just imposed the upper limit and the threshold. That is fact. So they imposed those upper limits and disclosure thresholds, and they did so arbitrarily. But it's also inherently, our second tier argument, milady, is not that there's procedural irrationality, but there's also substantive irrationality. There's simply nothing that justifies what has been done here. When you have a 100,000 rand threshold that applies across the board to all political parties and all independent candidates, plus you don't control for related parties, it's fundamentally irrational. Because you could have, it doesn't cost anything to set up a company. You could set up 1,000 companies and they could each make 99,000 rand donations. That is not contrary to this act. The respondents suggest, well, that could be criminal or that could be simulated transaction. There's nothing simulated about it. You are entitled to set up corporate entities. And they can donate according to this act, and they can donate up to 100,000 rand without disclosure. There's nothing inherently unlawful about it in terms of this legislation. We are saying that that is fundamentally unconstitutional. It doesn't meet the standard that My Vote Counts to establish, and it doesn't meet the basic rationality threshold. But we don't even...
So,
yes.
Even if the act itself does not say it explicitly, if you give 5 related donations of under the threshold with the objective of bypassing the limitation, but to be contrary to the act itself, and that then could be set aside. Especially if there is full accounting of the donations, full record keeping, full disclosures. Then you would be able to see whether or not donations are interrelated, or if it's done with an objective of bypassing certain provisions of the act.
Milady, the act does not, there's no objective to bypass the act. The act allows related parties to donate as much as they want. So it's not contrary to the act. And therefore there's no criminal or civil liability in relation to parties who want to set up multiple entities to donate. It's allowed. This act is irrational and unconstitutional for that reason alone. The disclosure threshold makes no sense whatsoever. It simply allows that kind of conduct. It's not unlawful. It's not so. And if it doesn't proscribe it, then no one can take issue with it. That's the point. There's nothing in this act that prescribes it. Nothing. It doesn't say it allows juristic entities. So the premise is it allows both individuals and juristic entities to donate. It doesn't put restrictions on related parties donating at all. The only thing that the respondents say is, it's difficult to control for related parties, and there could be some criminal liability. But there's no criminal liability. It's just not it's not contrary to the act.
But wouldn't the criminal liability come from the objective of the donations, which is what My Vote Counts is trying to address? Because you are saying unless there is public scrutiny on donations, it would feed into and facilitate corruption. So if a donation is given with the objective, for a corrupt objective, that in itself would be an illegal act.
Yes, if it's given for a corrupt objective, it doesn't. That's a separate issue.
But isn't the objective, sorry, Council, isn't the objective, as I understood why My Vote Counts is coming to court, is for increased transparency, because to address the possibility of corruption of political parties. Is that one of the objectives of My Vote Counts?
It's one of the objectives that My Vote Counts, but more importantly, it's one of the objectives of the legislation. However, it does not, the right often what the Constitutional Court has held is that often undue influence can be exercised in various ways. And it doesn't have to be corruption directly as classically defined. And what My Vote Counts 2 says is that the public is entitled to know all of those donations, and the media and NGOs are entitled to know, so that they can interrogate and they can draw the links and they can expose what the underlying premise of a party's support base is and what really drives a party. So it doesn't have to be corruption in a true sense. It's anything undermining the right to vote, because the right to vote is the right to cast the vote, but it's the right to cast an informed vote, where you know exactly what the parties are about, what drives them, who supports them, how big their base is, where it's directed. So it's not only corruption, it's also the right to vote itself and right to have access to information.
Isn't an informed right to vote also obtained from knowing what the party's policies are, knowing how they've performed if they're an existing party, if they're a new party, what the promise is, what the agenda is, what the mandate is, what policies they perform, what the values, what their vision is. Doesn't that all go to the body of an informed right? And not only who funds the party. That is but one aspect. And if the public does not know the full extent of who funds the party, does it detract from an informed vote when all the other issues are available as to what's our agenda, what's our policies, what's our values, what do we stand for, how we performed, how we voted on certain issues in Parliament? Isn't that more important to an informed vote?
Yes, Milady, this is an issue that the Constitutional Court actually expressly dealt with, and they said parties spend a lot of time on dispensing information to the electorate. That information is part. They spend sometimes over a year doing so. And those policies form part of what an informed voter would have. But what they also held is that is not enough. That's the express holding of the Constitutional Court, and I'll get to it, Milady, if you can. At the moment, I'm simply sketching out the matter. I'll get to the actual judgment, and all of this has been dealt with in the judgment. So, coming back, the 15 million rand upper limit is, we say, is irrational. Also, has not been properly justified. It's excessive. It doesn't cater for related parties. It doesn't cater for different kinds of parties. So definitely for some of the parties, 15 million would be much more than their annual budget, and therefore can completely influence them, contrary to and sway the party into more corrupt domains. And it's not that simply doesn't provide the guardrails that Section 19 and Section 7.2 of the Constitution require. And Section 7.2 has been interpreted, as I mentioned to the court at the outset, in the Glenister and Helen Suzman Foundation, to require the state to take all possible measures to ensure that corruption is eradicated. The third tier, so first is the 100,000 rand threshold. The second is the 15 million rand upper limit. The third is expenditure, disclosure of expenditure. And my lord, my ladies, we have set out why expenditure is an integral part of the information that's required. Now, expenditure was not expressly the focus of My Vote Counts 2, although what My Vote Counts 2 says is relevant for whether there should be disclosure of expenditure. Expenditure completes the picture in relation to a donation. So where you have a donation, let's say, 1 million or 2 million or 3 million, that is used for particular purposes. We know that there's public funding available, and we know that parties underuse or underutilize public funding. They rather prefer to use private funding, and they prefer to use private funding, it would seem, to cloak their activities. And what a voter is entitled to see is for what purposes is the 30 million contribution a year that's given by a particular donor to the DA or someone else used. Because that completes the picture as to why it's prized and why it's directed to that party. That is the picture, and they say, you know, the DA flippantly responds to it saying, oh, well, you know, they want to know whether we've purchased printers or whether we've purchased some other equipment. That is not, if that's all they've done, well, then that's great. That's the innocuous information that a voter is entitled to know that that's been used for. But it might have been used for other things. It might have been used for rallies somewhere or for other activities. We simply don't know. And that completes the picture. And we say that that forms part of what My Vote Counts 2, the holding in My Vote Counts 2, controls in this matter. And we'll take my lord and my ladies to those provisions. So that's our third pillar of our case. We then deal with the issue of the EMAA, the Amendment Act. The EMAA, which was passed and came into force in May 2024, just before the elections, and that legislation effectively changed the manner in which the disclosure threshold and the upper limit are determined. And it vested the power of determining those issues in the President. It also created a lacuna in the law. And My Vote Counts brought an interlocutory application or an interim relief application to ensure that in the interim, until this court has the opportunity to consider the merits of the matter, that there would be interim relief granted to ensure that there wouldn't be a lacuna. This was opposed by both the state and the DA. The judgment was granted in favour of My Vote Counts 2. First, a rule of my side was granted, and then the interim order in August 2024. And that effectively kept the old threshold and upper limits in place. But our challenge in respect of the EMAA principle is in relation to the President being given the discretion to determine the limits. Now, what's interesting is that in May 2024, immediately after Parliament had acted on the matter, they passed a resolution saying the President may determine the thresholds and the upper limit. And they didn't give him any guidelines whatsoever in doing so. That is how they understood the legislation, and they understood it correctly. They now try to row back from it, and they say, no, actually Parliament, the National Assembly must give detailed guidelines, must actually determine the limit, and then the President must agree or disagree with it. Now, that is not what this legislation says. It's clear that the President has the discretion to determine the limit. That's what it says on its face, and you can't unread that. But even if they are right, that the National Assembly plays some role, the President should have no role to play in the determination of those limits. He is the political actor in charge of a political party. He is the worst position to make a determination of a limit and threshold which the Constitution demands. He is an inherently and institutionally biased person. Now, it's true, the respondents are correct, that he is not the only biased person, and it might be that the parties in Parliament also have interests, but at least it's a watered down, it's a first of all, a more open process, and secondly, it involves all the parties. Whereas here, it's a singular actor that's given that authority, and that simply doesn't control for the constitutional principles that My Vote Counts 2 has enunciated and have been enunciated in Glenister. It's simply not permissible for the President to be given that power to determine. And we make that forcefully. And the respondents say no, but Executive Council drew a distinction between Henry VIII clauses, where the President was allowed to legislate instead of the legislature, and everything else. And everything else you can just delegate en masse. That is not what Executive Council Western Cape held. It's not what subsequent case law of the Constitutional Court has held. Janse van Rensburg, Darwood, Jassa, they all held that there are legitimate controls that you place on delegation. Because it is Parliament that's the lawmaker. It's not the President. The President is not the lawmaker. The President only gets into lawmaking pursuant to very specific subdelegation given by Parliament on issues where he's got specific expertise or it's practically essential for him to be involved. But in our case, where he is the one who's going to be either the beneficiary or the person at a disadvantage as a result of thresholds and upper limits, you simply can't give that power to him. It's not constitutionally permissible. It's not what the Executive Council of Western Cape allowed, and it cannot be suggested otherwise. That argument would cause a constitutional revolution if that argument succeeded. My Lord, my ladies, those are the key tenets of our case. Now, there are nuances, and I'll get to the nuances as we go through the key tenets, but I wanted to outline what our case was really about and what we base it on, and to debunk some of the major misdirections that the respondents tried to take the court on. So, if I may just start with the My Vote Counts 2 judgment, and I would like, could I beg your leave, my Lord, my ladies, just to hand up copies. It is from our authorities bundles that were transmitted. My Lord, I apologize. Yes, it's the one. It's the bundle that was transmitted as my Lord presiding indicated on Friday.
Yes. Does he start from here? It comes from the other side.
Yes. Now, yes, they indicated in their email that they would have hard copies of their bundle on Monday. Our bundles are here too, but they are voluminous, and I don't want to. We'll leave them with the registrar, but I don't want to hand the whole bundle. At the moment, I'm referring to My Vote Counts too. If I may. Yes, my Lord.
No, this was just placed here. I haven't seen this before. This was also just placed here on the bench. My files were all in another box of bags that I brought from home. I received blue files. When I noticed I got in this morning, there were no blue files. And I wasn't going to turn somebody else's stuff at the public person's expense.
So this is
the 1216 of 1277.
This is 1216 of our bundle of authorities, my Lord.
Yeah, this is one of those that I saw in myself on the weekend. But we were aware of the case.
Yes, of course, my Lord. Thank you very much. If I may take my Lord to page 1218 of that bundle. So I'd like to just contextualize what the Constitutional Court found and how strong and strident their holding was. Just to place all of that, place the rest of my submission on this. Paragraph 4, my Lord. Public and private sector corruption is a matter of great concern around the world, and it appears that the political landscape, and by extension governance, has not been left untouched. The need for efficiency and effectiveness in the prevention, containment, and elimination of corruption linked to private funding of political parties and independent candidates seem to cry out for urgent intervention. for corruption that follows from secret private funding could otherwise stealthily creep into our political and governance space, toxify it and fossilize it to our detriment, if it has not already done so. And then in 5, they say several issues thus arise for determination. And the first one and kernel of it, is the need to minimize the risk of voters putting into office or even electing into government a political party or independent candidate who is corrupt or somehow compromised. Right, my lord, if I may, and my ladies, if I could take you to 1219, paragraph 23. So this deals, as I indicated to the court, this deals principally with disclosure issue, but it also talks to general principles to some extent. 23 says, and when access is sought to information in the possession of the state, then it must be readily availed. A challenge is, generally speaking, likely to arise when information is held by any other person. This is section 32 of the Constitution. There, information is accessible only when required. And required implies the need to demonstrate that there is a legitimate reason to grant access to that information. That ostensibly serves the purpose of ruling out unnecessary or spurious requests. For some information might indeed be such as to render it necessary for a requester to explain why it is really said to be required. That is an internal qualifier. Information will thus be accessible only if the requester is able to demonstrate that it is reasonably needed or required for the exercise or protection of any rights. So that centers the inquiry that was before My Vote Counts 2, and then My Vote Counts 2 held that it is required, that private funding information is required for the purposes of the right to vote. And I'll explain in the breadth of terms in which they held that it must be so. The 24, paragraph 24. When then is the reasonable or best form, is the reasonable or best form in which certain information must be held? Should it be discretionary or obligatory that some or all information is held? How best should information be held to facilitate disclosure when required? For example, funding is generally given to a political party for the benefit of the collective membership, not an individual. Such information must be held or recorded. Similarly, the use of funding for independent candidates would ordinarily have to be accounted for. To do so requires record keeping and the preservation of that record. So they're building up, the court is building up to its main findings that everything, all information on private funding must be recorded, must be held, cannot be unheld, cannot be destroyed, and then must be made reasonably accessible. Then paragraph 25. I'm only reading the key things that I want to highlight to the court. I'm not, that's why I'm skipping certain sentences. It shouldn't be taken as anything other than just presentation of key aspects. 25, broadly speaking, the nature, importance and purpose of certain constitutional rights or information that relates to them could necessitate that information be kept and recorded for the sake of, amongst other things, transparency and accountability. Right, so that's the inquiry. It set the inquiry. It says you need to prove that you need the information for purposes of exercising rights. You've identified the right to vote and right to cast an informed vote. And what the court is analyzing is, does that encompass this type of information? And it goes through the exercise of that reason. And then it says in 27, and this is important, now it starts to analyze the actual right. And it sets out the right, and in 27 it says, the section highlights the right of every citizen has to make political choices. Choice is of its own a loaded concept, and much more is required of a choice maker if the choice to be made is political in character and affects important national interests. The gravity of the choice is more pronounced in relation to the right of an adult citizen to participate or vote in the elections for any legislative body. This is because of the centrality of elections in the functioning, preservation and effectiveness of our constitutional democracy. So what they were saying is that the right to vote and the right to make an informed vote is absolutely fundamental to the democracy. And therefore, information, when later on in the judgment, they say that information must be made available, they do so in that context. And the Chief Justice goes on to say, to recruit members or supporters, and it's the next paragraph, to recruit members or supporters and campaign for a political party or political cause, information would be needed. To be able to distinguish one party or cause from others would likewise require access to information about them. One also needs to know more about one's competitors to be able to appreciate their strengths, expose their weaknesses or wrongdoing, and magnify one's strength and make an informed comparison between her presumably more progressive policies and objectives and theirs. And what the court was saying is that those are critical constitutional objectives. And once you are dealing with the right to vote, you're not dealing with a private space. So it's not a question of making a donation to some sort of a bowling club that you have. It's making a donation to a political party that is contesting elections at the highest level, that and those parties make decisions of the highest importance in the country. Therefore, they are held to different standards, and those that donate to them are in the public domain. They are not in their private sphere. So these arguments relating to, we must keep the secrecy and private because of the privacy interest, well, that has been argued and decided by the Constitutional Court. And the Constitutional Court has said that those privacy interests are worth nothing in the context of disclosure of funding of political parties. That is what that's what the effect of the Constitutional Court's, this argument was run fully. This argument was made by the DA. They ran it in this court, in My Vote Counts Too. They didn't succeed before Mia J. They ran it on the papers before the Constitutional Court and then decided to withdraw their opposition to the confirmation. This is all old news. The privacy interests are all old news. It's been decided. Paragraph 30, over the page, 1220, my lord and ladies. The issues before us must thus be addressed as they ought to apply to political parties and independent candidates for any constitutionally recognized legislative body. After all, the need for recordal and disclosure of information ought to be fundamentally the same for all political parties and independent candidates, regardless of whether or not they are registered or seek to hold public office at a local, provincial, or national level. And the parties in this matter have all grounded their contention on the Constitution. It is to those constitutional provisions that they now address. Then they say in 31, towards the end of paragraph 31, they say regular elections, accountability, responsiveness, openness, and public office bearers who are committed to the core values and principles of good governance laid down in section 195 of the Constitution are what would facilitate the attainment of the South Africa we all deserve. So, my lord, and my ladies, what the court was saying is that we need office bearers who are true to their oath, and one way of doing that, of ensuring that, is to have access to all information in relation to their funding. And they carry on. But this is also important, this dictum that I've just read is also important for the purposes of our upper limit case, because it is that kind of accountability and responsiveness and openness that's promoted by a restriction in relation to the upper limit. And the Parliament has clearly not done its job in that regard, because it simply imposed a limit that far outpaces any other jurisdiction, even that they've cited. We have other jurisdictions, and I'm going to talk a little bit about that fool's errand that the executive and the DA engage in by giving you very, very cherry-picked examples of certain jurisdictions. But I'm just, at this stage, just placing the principle that is not, our Constitutional Court has pronounced on the centrality of elections and the fact that it's a constitutional right. So you can't just borrow from other countries and say, well, they've, for whatever reasons, they've determined those as the limits, upper limits, or they've determined that is the threshold. It's just not a useful exercise. It's not a useful exercise because it has to be done in the South African context, both legal and socio-economic context. 32, paragraph 32. The right to vote derives its fundamentality from the central role voting plays in the establishment, functionality and vibrancy of a constitutional democracy. It is a prerequisite for the very existence of the legislature and the executive at all levels of the state. And the proper exercise of that right is so critical to the coming into being of our political arms of state and the effective and efficient functioning of the entire state machinery that the need for transparency and accountability from those seeking public office is self-evidently more pronounced. The future of the nation largely stands or falls on how elections are conducted, who gets elected, how and why they get voted in. Only when transparency and accountability occupy center stage before, during, and after elections may hope for a better tomorrow be realistically entertained. This is not just a linguistic flourish. This is the encapsulation of the centrality of the right to vote and the right to make an informed vote. The Constitutional Court is, yes.
Even if we accept all of these arguments, isn't the issue that this application is premature? Those limits have been on our obsolete. There is pending before the court, obviously Judge Jalari's order is in place, pending earlier this outcome of this application or the decision in Parliament to the President. But that is now pending, so those limits haven't been set. Once they have been set, so that's separate from your primary argument on whether there should be a limit in the first place. But your second argument, which would apply to the thresholds as well, those limits haven't been set. So how are we to determine something where there is a process in place in terms of existing legislation, that process must be seen through? And if, this argument has been raised in the heads, if you're not happy with the outcome of that or the limits as determined, then take those. But my concern is that we, as my sisters pointed out, there is a real separation of powers issue in that regard.
Yes, Milady.
Can I just add on to this? It's also not totally correct that in the deliberations nothing was considered about limits. Because there was a presentation in November or December of 2023, and there was a person commissioned, a certain Dr. Badenhorst, that made certain inputs to the committee. We dealt with and referred inter alia to Italy, Uruguay, etc. And those were them. I didn't want to interrupt you, but on that score, those are issues that will be considered by the committee in due course, now in the new process. I'm not sure that, as in the past, you're trying to make the
Yes. My Lord, if I may make submissions in relation to that aspect. If we just take, I just want to sketch out the chronology. My vote counts 2 judgment was handed down in June 2018. Pursuant to that judgment, the legislature engaged in drafting PPFA. PPFA became an act but wasn't brought into force until 2021. It became an act in 2019. It was brought into force in 2021. In 2021, the 100,000 Rand and the 15 million Rand limits were set. The thresholds and the limits were set. That is what we are challenging. In relation, there was nothing prior to that. So all of the presentations, my Lord is quite correct. There were presentations made after the fact in relation to any new limits that might be determined. That is a separate issue, and that's not connected with the challenge directly. And if I may just address the mootness point or right, I'm never sure whether it's mootness or rightness in this particular context, because we have, it could be one of both. The Parliament, the chronology is that 8th of May 2024 was the date on which the EMAA came into force. On that date, we say a lacuna has been created, and that was our case before Jalari J, and he granted an interim order to deal with it. So currently, pursuant to that interim order to preserve the status quo, those limits are in fact in place. That's the first issue. That's not a complete answer to Milady's question. I'm just sketching out the entirety of The second issue is that the EMAA, we say, is unconstitutional. The provisions that made a change to the 100,000 rand limit, the disclosure, so sections 8 and sections 9 of the Act are unconstitutional for the reasons I've alluded to, but I'll go into in more depth. The President should have no involvement in the determination of those amounts, and the provision is unclear and contrary to Darwood and Janssen van Rensburg, and it's contrary to JASA. And we'll make our full, we've already set out the case obviously in our heads, but we'll make fuller submissions to this court in due course on that score. So once those provisions go of the EMAA, then it is back to the PPFA as it stood before amendment, because those would be in accordance with the doctrine of constitutional invalidity. It's fully retrospective. The court simply declares conduct to be unlawful. It doesn't. It's unlawful ex tunc, unlawful from the date that it's been promulgated, and therefore EMAA provisions that we are dealing with would be impugned and would be taken back to what they were under the original PPFA. But so that's the second issue, and on that score there would be no mootness or rightness argument of any sort, because we would be back to the 2018 version of the Act. The third, or 2019 version of the Act. The third issue is that the new Act, as amended, so EMAA amended certain portions, but it didn't amend portions, for instance, that don't deal with related parties. It didn't amend portions whereby the threshold, first of all, exists. So the threshold does exist, and we say it shouldn't exist. But secondly, the threshold also doesn't differentiate between different tiers of government and between donor and donee. It doesn't do any of that work. So the threshold will again be a number. And that number is simply not constitutionally acceptable. It's not it's not in accordance with my vote counts too. So even if EMAA survives the Executive Council attack in relation to unlawful delegation, it doesn't survive the attack on its core tenets. And therefore, the mootness argument simply doesn't arise. The legislation is bad in amended and unamended form. And we'll argue that, and I'll take Milady and my Lord through the legislation to show why that is so. So if I may continue with the exercise in relation to my vote counts too, because it is really important to appreciate how broad the ruling is. The ruling is not simply it wasn't giving discretion to Parliament. It was saying, Parliament, you failed to do your job as the Constitution requires you to do. You are part of the state, and you are required to take the legislative measures to bring to bear all reasonably possible force to ensure that disclosure takes place. So we were in paragraph 33, my Lord Miladies. This case is, after all, about establishing a principle-based system that will objectively facilitate the meaningful exercise of the right to vote, regard being had to its veritable significance, which he's just outlined. The court has just outlined the veritable significance, and then he goes on. The system's inbuilt capacity to sift the corrupt from the ethically upright is an indispensable requirement. Indispensable. For this reason, any information that completes the picture, and this is Milady's question also in relation to what is actually needed for a voter. Any information that completes the picture of a political party or an independent candidate in relation to who they really are or could be influenced by, in what way and to what extent is essential for the proper exercise of the voter's will, in which our government is constitutionally required to be based. An environment must thus be created for the public to know more than what is said in manifestos or during campaign trails. As will become apparent below, what is implicitly envisaged in Section 19 is an informed exercise of the right to vote. So the court has dealt with the issue and has said, it's very interesting what you have to say, ostensibly. You are saying you are whiter than the driven snow. We want to see whether that's the case. And the voters are entitled to all information that's about private funding for that purpose. That's what the court subsequently held. Then 34, for every citizen to be truly free to make a political choice, including which party to join and which not to vote for, or which political cause to campaign for or support, access to relevant or empowering information must be facilitated. Not only must the information be held in one form or another, it must also be reasonably accessible to potential voters. They needed to be able to make a quality decision to vote for a particular political party or independent candidate. And then the next paragraph is also partly important. 4, there is a vital connection between a proper exercise of the right to vote and the right of access to information. The former is not to be exercised blindly or without proper reflection. And then former Chief Justice's dictum is cited in support of that. Then paragraph 36 says public office is so important that it is only to be ascended to by those who have been properly examined and found worthy to represent the electorate. And that may only be so with the benefit of information. Without it, the ability of citizens to make responsible political decisions and meaningfully participate meaningfully is undermined. 37, this is the crux, the reason why I'm going paragraph by paragraph. This is the crux of my word counts to a finding. And it is an extremely powerful statement of the centrality of the right to vote, the importance of the right to get all information, and the fact that that information must be in totality collected, secured, and disseminated. 37. By its very nature, the proper exercise of the right to vote is largely dependent on information. No wonder it takes months, and at times even a year or more, for political parties and independent candidates to wage a campaign for public office. This entails imparting whatever information they consider necessary for the electorate to know more about them. That information sharing process takes the form of many house-to-house visits, town hall and stadium meetings, radio and television interviews, and newspaper articles. Billboards and advertisements are routinely used. There's a wide coverage of electoral campaigns on all media platforms. Then 38. That information is generally calculated to have the voters believe that the candidate it relates to can be trusted and deserves their support, because she's best placed to serve citizens in the public office being campaigned for. It seeks to demonstrate their abhorrence. So the parties seek to demonstrate that they have an abhorrence of corruption and all facets of unethical conduct. It is also meant to assure the public of their commitment to our constitutional values and to good governance. The centrality of the information to this process cannot be overemphasized. And then, this is some of the crux. This then means that political parties and independent candidates should not be left to pick and choose what information would be held, preserved and disclosed to those who depend on information, to determine to whom to entrust their future, that of the nation and posterity. All information necessary to enlighten the electorate about the capabilities and dependability or otherwise of those seeking public office must not only be compulsorily captured and preserved, but also made reasonably accessible.
So isn't that the key issue? It's necessary to enlighten the electorate. So how can a 50 rand donation from an individual be necessary to enlighten, so that limits the ambit of the protection of the right? And how can that be reasonably necessary? It's particularly in light of the purpose to avoid corruption.
Yes, Milady, the court goes on to make pronouncements in relation to the totality of the information, and I have read paragraph 75 also, where they made it clear that what they meant is that everything needs to be recorded and held, and cannot be unheld, and what the only possible exceptions where the state might be able to justify is if it's trifling, negligible amounts, is what they have stated. Like maybe a 20 rand donation, I think is what they've cited as an example, or someone volunteering to do some work for the party. Now, that is not, first of all, it's for the state to justify it. It's not for us to justify that, because the principle is full disclosure as a general proposition. But secondly, That is not what's happening here. 100,000 rand threshold is simply not, we are not talking 50 rand donation. And the 100,000 rand threshold is without control for related parties at all. And it's without control in relation to the tier of candidature. So the people at local government level who are independent candidates, for whom 90,000 rand could be the entirety of their basket of funding, are treated in the same way as a party of Democratic Alliance's size, which has, according to it, hundreds of millions of rand worth of expenditure. Well, you know, this legislation is fundamentally irrational. There's just no, you can't, it's irrational even if we didn't have my vote counts too. If we just were relying on the irrationality like a new National Party case. But we have my vote counts too, we have the right to vote, and the standard is one of proportionality. The standard is not one of rationality when it applies to the state in this case. So, Milady, that would be my response on that score. Paragraph 40. The reality is that private funders do not just thoughtlessly throw their resources around. They do so for a reason, and quite strategically. Some pour in their resources because the policies of a particular party or independent candidate resonate with their world outlook or ideology. Others do so hoping to influence the policy direction of those they support to advance personal or sectional interests. Money is the tool they use to secure special favors or selfishly manipulate those who are required to serve and treat all citizens equally. And this is where we say it's the centrality. This speaks to the centrality of that information, but it also speaks to the centrality of information about expenditure. Because expenditure, how the political parties use the funding that they get, is a critical element to understanding the full chain of fund flow and why the donors might be interested in donating to a particular party. And then the court says unchecked or secret private funding. So not only does the court deal yes.
Yes, that's 11:37. Let's take a 10-minute break. I also want to check. It seems to me the aircon's warming up instead of cooling us down. So let's take 10 minutes break. Let's say it's 11:40, 15 minutes. We'll be back again. So that everybody is the first substantive part of the notice of motion. Now I understand this might be how it was in soft copy form. What does the hard copy look like that was filed with?
My Lord, may I be of assistance in explaining? So the reason why I took, my Lord, to this version is that it shows the changes we've made from the previous. No, my Lord, I'll explain if I may just. I'll explain.
All I want to know is where's the original.
If you, my Lord, turns to page 612 of the bundle.
It's in the other bundle now. Just open it up at 612.
.609 is where it starts. Maybe 609. Yes?
Yeah.
609, my Lord. That's the notice to effect the amendment.
Yeah.
And these are the amended pages are then inserted at 612 to 650.
No problem. My question was where the original.
Yes, of
That's
this
my
document,
question.
of this, the notice of amendment.
Of all 4 documents.
Yes, we have, from the applicant's perspective, we have originals of some of the documents. Some of them are electronic.
But why are
and
they not
therefore,
in the court file?
my lord, most of these are.
These are bundles for use in the court. But where's the original papers on the court file?
My lord, there
I
might.
didn't want to take the point.
Yeah.
I told you in chambers, I don't want to take technical points. As far as I know, as the presiding judge, I haven't seen the full original court file. I've got bits and pieces in that file, the brown cover that's lying over there, and there are some documents missing from that file. Because remember, I did at least one case management meeting in it. So I know what was there. So before the end of tomorrow, I want the file in order.
My lord, if we may.
Because I do cross checks, Mr. Mossovich. That's the way I read. Because I can't rely on copies of copies of copies. And we follow that. So is there a document like this in the court file?
My lord, there would be a document filed like this because it would have been
And
filed.
I take it that would have been signed.
Yes, but the signature might be electronic because
No, you see, because the one at 402 that I have is unsigned.
yes, because that was the notice of intention to amend.
But it must be signed still.
No, the actual notice would have been signed, just not the.
No. The notice of motion is unsigned at 402, my copy.
No, my lord, the notice of intention to amend is at page 394.
Yes, I have.
That is signed.
And that's signed.
And that's the document that has to be signed.
Yeah.
The notice of this is an annex. 397 and 398 is an annex to that notice. So that doesn't have to be signed. That just reflects what changes are sought to be made under Rule 28.1.
I know that. So when it says in red line, what does that refer to?
That's the red lined version at page 398.
So it's only those numbers under 6 changes to 3, 5 changes to 2.
There are various paragraphs that are inserted. Paragraph 2, 3.
And the blue, where does the blue?
No, that's the red line means.
What does the blue mean?
The red line means both in blue and in any other color.
No.
That's just the term that's used. Red line.
Oh, is that what it means?
Yes. That's
How would I know that? Do you understand how difficult when one gets papers that you don't have the original?
yes.
But all right.
My lord, that's just to explain.
I can tell you
so
now.
the reason, my lord.
No,
sorry.
wait.
Apologies.
Before tomorrow morning, I want a proper court file.
We'll update.
Before we start tomorrow morning.
May we
You can
see your registrar after?
You can see
close of
my
play.
registrar after, because there's a habit of sending stuff in the evening and nobody can access it, as long as it's in court office hours. This file should have been in order. Should have been in order. We had to phone around last week and send emails about heads and all sorts of things. And it's the applicant's duty to see that the court file is in order. So it's there. I want it properly done before I walk into court tomorrow morning.
My lord, that will be done. We are working off your bundles. Hopefully those are complete in relation to.
I don't know.
To what we
I
want.
read what was given to me. I just accept it. It's there. I must just say, Kelly, Mr. Mossam, I'm taking up 5 minutes of your time now. But there was a point on Friday evening where we were discussing from my side that I'm not going to be treated like this by practitioners. I'm not going to hear them today. But then we discussed it and we said it's also not fair to everybody else if the applicant acts this way. So let's do our best over the weekend and try and get ready for this morning. I was very tempted to say, go get your house in order and then you come back to us. This is not the way I've been treated in the last more than 25 years on the bench.
My Lord, the bundles, as far as I'm aware, were delivered to your respective chambers in December,
Yes, I know.
at the time when you directed they should be delivered. And the heads of argument of the applicant were delivered timelessly to your chambers.
Yours and
all
the DA is
three
one
chambers.
time.
I apologize that the original court file is not updated, but the documents that were relevant to the proceedings as agreed with the parties, the full bundle,
Because
was
you
delivered.
know, Mr. Mosevic, if in the event that you are successful, this matter must go for confirmation. On what papers?
Yes, my
You
Lord.
understand my concern?
My Lord, your concerns are valid. I'm simply saying, I'm hoping we can continue with the matter.
No.
And we'll update the court file, the original court file, over the
We've
overnight.
spent hours and hours and hours preparing. We've sacrificed the whole weekend and 2 days last week. The
Yes.
three of us.
I think the parties are indebted to this court. And I think the questions show that the judges know the papers completely.
All right,
may
now
I-
at the two,
May I
at the
continue?
pre-amendment and the...
Yes, given that we've gone to 398 and 612, this is just to show 398 is the notice of intention to amend. That's the document that was attached to that. That shows what changes there were from the original notice of motion. Then 612 are the amended pages. So this is the final document as the notice of motion that we seek, and that's filed under notice under 28 Rule 28.7. My Lord, if I may refer to the notice at 398 because it shows what changes we've made, and it will assist the court, I think, in navigating through the pre and post amendment version. If you could indulge me, because the blue and the red on it show the changes we've made as against the 2023 version of the notice of motion. And so I think to assist the court, that will probably be helpful one to refer to. My Lord, if I can take you to the pre-amendment version of the Act itself. If we could look at the notice of motion together with the Act. So the notice of motion attacks section 8.2, 91A, etc. In paragraph 1. I'd like to focus on 8.2. We'll go through each section and I'll explain what our argument is. So 8.2 is the section that says a political party may not accept a donation from a person or entity in excess of the prescribed amount within a financial year. Is my Lord there? The ladies? That is to be read with the regulations to that Act at Regulation 7. Sorry, at Regulation 9. That's also attacked in paragraph 1 of the notice of motion. It says a political party may not accept a donation from a person or entity in excess of the prescribed amount. And then paragraph 9 of the regulation says disclosure limit. The threshold referred to in section 91A, the one that we've just read,
is 100,000 rand within a financial year.
Mr. Masevich, we do not have the regulations in the bundle, so perhaps if you want
Sorry,
to have a copy.
I think it's at the back. They are attached to the Act. They should be attached to the. Are they not on your version?
I think it's best if you hand up a hard copy.
Yes.
Then,
Yeah,
we can look at the section together with the regulations, otherwise we're going to be turning
Absolutely.
to...
No, we have those. We have those. That's really right.
Are you dealing with the pre-amendment?
Pre-amendment and then post-amendment.
Because the regulations to the post
So this is
those are
the pre-amendment, and that's the post-amendment. Right, so the one with highlights in the front, on the front page, is post-amendment. The one without the highlights in the front is pre-amendment. My Lord, my ladies. So what I was, now that you have the version that I'm working from, it will be easier. There's pagination at the bottom of that document. 6 of 14.
of the
Pre-amendment.
the pre-amendment is the one without highlights.
Correct, my Lord.
Where do you see page
At the bottom right, it has,
of 14?
I'm looking at 6 of 14.
So I take it this wasn't paginated in your bundle.
This is not from our bundle. Our bundle only contains the amended version of the, but there is a,
So you knew on Friday when you sent us
no, I realized this morning.
the volumes that you're not sending us everything.
My Lord, I realized only this morning.
That also we landed on the bench this morning, the blue file, the Linda's file. You knew on Friday when you sent us that bulk that you are not sending us everything that we need.
My
Because
Lord,
this wasn't in there.
my Lord, I didn't know that this wasn't in there.
Why didn't you know?
Because it referred to the Act, and it wasn't clear from the index whether it's free or post.
what you were going to refer to this.
My Lord,
That's not the way we operate, Mr. Minister.
yes. The Act, I think,
But carry on, we are wasting time because you wasted our time. Carry on.
yes. My Lord, 8.2,
Yep, it reads the same in both here.
a political party may not accept a donation from a personal entity in excess of the prescribed amount. And if I could take the court to page 13 of 14, 9, paragraph 9 of the regulation. The threshold referred to in section 9(1)(a) of the Act is 100,000 rand within a financial year. Are you there? Is the court there? Yes. So this is those two provisions must be read together, and it's the Parliament that determined the 100,000 rand. We say that first of all, that 100,000 rand applies to every political party and every independent candidate without distinction. It applies in relation to related, so related entities can donate below the threshold. There is nothing in this Act and nothing in section 8.2 that controls for related entities. It's simply one limit per donor, whoever that may be, at whatever level, to a political party, a specific political party. So the other important point about this is that it focuses on the political party, on the donee, not the donor. So somebody could donate 99,000 rand to a number of, let's say, independent candidates or a number of parties, and no one would know that they've donated to those parties. All it says is that if a political party receives more than 100,000 rand, the respondents say in a year. We say that that's not clear from the legislation, because paragraph 8.2 says you may not accept a donation in excess of a prescribed amount within a financial. Sorry, is this 8.2 is the upper limit? Sorry, 8.2 918. Sorry. No, sorry, I'm mistaken. It's 918. Sorry, it's one I intended to refer to is 918, not 82. 918 says a political party must disclose to the Commission all donations received above the prescribed threshold, and that's the one to be read with paragraph 9 of the regulations. And that doesn't control for related parties, doesn't control for what level of government is involved, and the focus is also on the political party. It says that if a political party receives a donation above 100,000 rand, it must disclose. So if a number of political parties receive a donation from the same donor of 99,500 rand, that doesn't have to be disclosed. Also, if there are related donors who donate 99,000 rand, they don't have to disclose if they don't breach the threshold of 100,000. We say the way that 91A is framed, it's actually per donation, but the respondents argue it's in a financial year. I don't think it makes a huge difference one way or another. It still suffers from the same problems with related parties, and the fact that the 100,000 rand is not tailored to specific political parties or the size of political parties. Yes.
It's been dealt with by respondents. Their counter-argument to this is that, well, this is an enforcement issue. You can look at then piercing the veil of the different corporate entities in order to ensure that there isn't a subversion of what's intended by the legislation. I'd like to hear the response to that, because that's certainly the argument they raise.
Yes.
Whether or not, how do you overcome that argument?
Yes, and they say it's if there are simulated transactions, then that. The reality is, under this legislation, there's nothing stopping the incorporation of entities. It's just not proscribed. It's not a question of intention of the legislation. The intention of the legislation is to allow juristic entities and individuals to donate, and juristic entities can donate below the threshold without being disclosed. So there's nothing, it's not a question, it's just not proscribed under this legislation. And no one, even if you read, in whatever way you read this legislation, it doesn't proscribe Mr. X incorporating 5 entities and donating 99,000. He'll or she'll say that's what they intended. It's not; these are not simulated transactions. Simulated transactions where you didn't actually intend to do what you did. Here they did intend to incorporate an entity and donate from that entity.
But isn't there other legislative instruments that will deal with the attempt to bypass the intention of this act? Isn't there other instruments that will address corruption or undue influence other than this act? I don't think we can only look at the act in isolation. We need to look at everything. If it's a company that's making a donation, that's doing it for an improper purpose, then we look at the Corruption Act, Corrupt Activities Act, the Prevention of Corruption. We look at POCA, we look at the Criminal Procedure Act. We can't just look at this particular instrument in isolation and say because it doesn't provide for ABC, never mind that there's another instrument that does address ABC, this act is unconstitutional.
But there's nothing that addresses it. It's just not prohibited. If it's not prohibited, then you can't be found to be...
But if the donation is made with the attempt or with the intention of corrupting or unduly influencing a political party, of getting a favor, that donation is made with the intention of corruption, then that aspect will be addressed by the Prevention of Corruption, will be addressed by the Corrupt Activities Act.
By PRECA.
And by the Criminal Procedure Act or the common law or other legislation that exists. So if the intention is a corrupt intention, this act itself may not have addressed it, but it doesn't mean to say there are instruments or legislation that does not address it, because it will then fall under the Corrupt Activities Act or POCA.
I just want to add on to that question because of that legislation. How far does Section 19 of the Act take?
Of this act.
19.3 in particular.
In the amended version. Oh. Yes. Yes. This case is so. The Constitutional Court, if it's a crime, if it's given for some illicit purpose, and it's a gratification in terms of PRECA or in terms of this section or whatever it may be, then it will be a criminal offence. That does not answer the question whether it is. There could be the Constitutional Court made a ruling in relation to disclosure of information, not necessarily where there's proven corrupt link, but where there's influence that person's donation could have on the party. It doesn't have to be an illicit influence necessarily. The voter is entitled to know about it. It's not a question of, we're not talking about, yes, if it's corrupt, well, of course it might be dealt with if the enforcement mechanisms are in place. That's not the point. And Glenister case dealt with this post hoc review issue in any of it. It said post hoc review is not an answer to having the right structure in relation to the agency as a whole. So it's no good saying, well, there might be, if it's a corrupt transaction, we could potentially pick it up if the hawks are alert and alive to it, or someone makes a complaint. That's not the purpose of this legislation.
No,
The Constitutional Court.
Then I apologize, Mr. Mosevich, because my engagement with you was based on your submission that there's nothing in this Act that prohibits donations in excess of 99,000.
Yes.
There's nothing in this Act that makes any donation illegal. So my engagement with you was in respect of that aspect, that this Act need not render any activity unlawful if there is another Act that addresses the unlawfulness of the donation.
But, yes, Milady, I was simply
So
saying...
that was the context within which that engagement took place. Not that the Act or that a donation needs to only be unlawful or with the purpose of a corrupt intention. So I understand your argument, but as I say again, my engagement with you was in respect of your submission that this Act doesn't declare any donation unlawful.
Yes, PRECA existed, Milady, before My Vote Counts 2 was put in force, and the Constitutional Court wasn't interested, didn't know, but the Constitutional Court ruled that there has to be disclosure of donations. They didn't, just because there's criminalization of bribery or corruption, and that could be, if it's a corrupt transaction, it could be picked up in that way.
We are not seeing each other, Mr. Mosevich. I am not engaging you on your whole argument. I was just engaging you on your submission that this Act is irrational because it failed to criminalize certain donations. And my engagement was with you because if a donation was made with a corrupt intention, this Act itself need not criminalize it because there are existing instruments that deal with it. It did not go to the full extent of your argument, only that limited submission that you made.
Yes, I didn't say that it didn't criminalise. I didn't say there wasn't other legislation that criminalised. You're quite correct that there is other legislation that criminalises. I'm simply saying that is not our complaint. Our complaint is that the prescribed amount is irrational because it doesn't achieve access to information that the Constitutional Court said should be achieved. And it doesn't make sense. It's incoherent. The legislation is incoherent. It doesn't provide the parameters that it needs to provide.
Now, your client partook in the process of this lawmaking.
Yes.
We saw the minutes and the reports, etc. These issues were raised there as well.
Yes. In the amendment.
For the
Yes.
amendment.
Absolutely.
Right, I see it's 1 o'clock, so till 1:45. That's it. Let's just find out. Anybody have particular difficulties this afternoon with time? Should we go over the time or not? Mr. Mosevic, as I have it, you've been on your feet for 1 hour, 2 hours 30, but we've taken about 15 minutes of your time.
Thank you.
So you still have 45 minutes
Thank you.
when you come back. So what we might want to do is so that we don't, who's up next?
My Lord,
You,
my
Mr.
lady, so I'll be next.
Yeah. And for how long are you going to be on your feet? I'm just trying.
I was
You've got
given
1.5
an
hours.
Yes, 1.5 hours.
So we might want to come back at 1:45 and then we do your argument, which will take us to 3:03 roundabout there. Then he goes up to. I'm just thinking whether we shouldn't move it around a little bit so that we don't have counsel in the middle of the argument by this afternoon. But you can speak to your colleagues, because if we have the DA, ActionSA, and the speaker, that takes us to 2 hours. But then we're already over after 4. So we might want to take ActionSA and the speaker after Mr. Moshevitz, if your colleagues are okay with it.
My Lord, as I have it, according to your timetable, we end at 2:30, and then it's 1.5 hours until 4 o'clock. So if we end at 4 o'clock, then the executive ends at the end of the day.
We never know with the interactions from the bench. It might take a little bit longer. Then we have to break Mr. Manager just before he reaches his. So the parties can discuss it so that it makes sense on how that we can have a complete set of arguments. If you feel you're going to cut it short,
I won't cut it short, my Lord. I think I would need to.
yeah,
Just in terms of our prep, we worked on the 1.5 hours.
because both you and the DA, we could potentially slot in tomorrow morning then. And
If the court were
the
minded to do
speaker
that,
and ActionSA, we can do them this afternoon. And
If-
then take a break.
yes, we could assist the court even better by giving the court a written note in response to the argument, which then the court doesn't have to take copious notes and the argument can be managed better.
You can advise us when we come back
As the court does.
as to how you want to do it. I hate to have counsel interrupted overnight in their argument and then have to come back the next day. The registrars will liaise with the security to allow you in time.
Does nothing to limit that.
So that was from April 2021. That was the position until.
Correct, and I'm going to the Amendment Act. I'm going to the Amendment Act. So the Amendment Act, if I can ask the court to look at that, that's still Section 8.2, and 8.2 has not changed in its terms. Actually, ironically, this hasn't changed at all. So it doesn't actually deal with independent representatives or independent candidates. Even though they amended all the other sections to take care of independent candidates, they didn't amend that section. But that's just a footnote. That's not the thrust of our complaint. That is irrational, but that's just a footnote. So it cross-refers to prescribed threshold. Now, I've taken this court to the regulations, which are at the end, where the upper limit of donations is dealt with in Regulation 7. And Regulation 7 again inserts the President into the process. So we have the same complaints about the President being inserted into the process here as we do with the threshold. And I've taken the court to 9.1a and Regulation 9. The same problem arises in relation to this, because what it does now is that not only is the prescribed threshold does it not only suffer from all the maladies that I've described, not dealing with related parties, not dealing with having one prescribed threshold for everyone, one size fits all, but it also says the President determines it, not the Parliament, but the President. And we say that that's unlawful delegation of power to him, and it's impermissible in terms of our Constitution. When it says the state must take all reasonably possible measures, it's Parliament that must do it. It can't be a tainted political actor, one who has a particular interest institutionally to have either a lower limit or a high limit. So, my Lord, my ladies, what we say is the same issues that plagued the original Act, plagued this Act, but they add a further issue that the President now is inserted as the decision maker. And that's simply not an acceptable, constitutionally acceptable position. So that's our, that's our complaint. That's the nub of the complaint. So a lot of the issues are not fixed by the PFA. So from the PPFA to the PFA. It's just not remedied. And in fact, what we have is an addition of the President interposing himself to determine the amounts. And may I take the court back to our notice of motion, because it will relate to the section. I want to show how it's how we reflect in our notice of motion.
Should we look at the one that we find at 31412, or should we look at
please 398, if I may. It's the same as 612, but it's just easier because I can show you what things we've added and why we've added. It's just, it's only for ease of reference. I don't, I know the red line is unsatisfactory, but it's easier in this context. My Lord, my ladies, so if we look at our main challenge, so everything that's not blue, underlined in blue, or red.
So I must accept the blue line is a red line.
Yes, my
Mr.
Lord.
Moskovich, the problem is that my brother has a colour copy, but my sister and I have black and white.
So,
Well, I've got a black and white copy.
my lady, it's whatever is underlined or crossed that's new. If I may say, we'll substitute those pages with the coloured.
No, it's fine. We'll delete this file. I've made notes. You can't have access
Right,
to
okay,
it.
no.
And there are no folds on the page.
That's fine. I'll follow.
Thank you, my lady. My Lord, my lady, so if I can just orientate the court, the first paragraph says declaring sections 8.2, 918, 9.2, 12.2d, we'll park that issue. I'll come back to 12.2.
24.1, that's the one dealing with regulations that I've taken the court to. And then regulations 7 and 9. So those are all still attacked, both in the original Act and in the PFA, the as amended Act. And that is why we've said it's either the original Act or as amended in its pre-amended form. So that's our first set of relief. We also, my lady and lords, take issue with the fact that expenditure is not disclosed under this Act. So, my lord, my ladies, I've set out in outline our challenge on that score. But if I may take the court to section 12 in the old Act, in the PPFA, 12.2d. So we say that in 12.2d, what it should include are not only donations, 12.2d2 in particular, but it should include expenditure. So that's part of our challenge. We say that that's what must be disclosed to the IEC, and that's currently not disclosed. And that's common cause between the parties. They're not currently disclosed. They disclose it on public funding, but not on private funding. And we say an integral part of the right to an informed vote is to know the full value chain, the full flow of funds in relation to a donation. So what is the donation used for? And this is particularly heightened by the fact that and this is on the papers, many parties don't use up their full quota of public funding. And public funding you can use for any party activities. So what is the private funding being used for if the public funding is not being exhausted? And there are tens of billions of rand that's not being used by the political parties. That simply heightens the suspicions. But of course, we're not dealing with suspicions. We're dealing with Ferreira versus Levine, objective unconstitutionality. I'm simply saying that if expenditure is not revealed, it doesn't give you the full picture. And I've taken this court to My Vote Counts 2, where the Constitutional Court was at pains to say, what you need is not only what the parties tell you, but the full picture in relation to the party, the things they are not revealing. And that has to do as much with the funding of political parties as with what they use the funds for. Because that might reveal what is the actual agenda and what is the funding being provided for. And that's critical. It's a critical part of your right to know. And we are attacking these sections in terms of the reporting obligations to facilitate that information being given to the IEC, which will then be given over to the public. So, my lord and my ladies, that's the purpose. I just wanted to take you through that provision to show that that's the purpose. And that's not something that's rectified. If we look at the PFA, so 12.3, no, 12.2d is not rectified. 12.2d2 still has the same provision. And it still does not facilitate information about the expenditure of political parties. And we say it's the same issue that arises whether it's PPFA or the PFA. It's the same issue. That has not changed. If I may take the court to our next section that we challenge, and that's 12.3c. If we can look at the unamended version, the PPFA. So it says, 12.3c says there must be a listing of the donations under the threshold prescribed in section 9.1. And we say that doesn't include expenditure. So again, although the party needs to report to the IEC on donations, it doesn't have to report on expenditure. So that's the same point I've been making. It's just another section that deals with that issue.
Wouldn't financial statements include expenditure?
It's in globular terms. So the financial statements would simply have all expenditure. They wouldn't say, this is what we use private funding for. Whereas in public funding, they need to delineate precisely what they need to demarcate what they use the public funding for. And that's what we're seeking in respect of private funding. So in financial statements, Milady is quite right. There would be a globular description. We use generally our expenses are the following in broad terms. But they will be in very broad terms, whereas the public funding expenditure is very specifically, there needs to be very specific accounting for that. And that's what we're seeking in respect of private expenditure, because we say it's an important element of an informed vote under the rubric of the Constitutional Court's ruling and the constitutional values and rights that we've set out. Right,
Before you proceed to a further section, are you going to address the procedural irregularity that you say affects this procedure? I think it dealt with the lack of public participation because, if I'm not mistaken, the Speaker and the Chairperson of the provinces says that we don't have jurisdiction to determine that. Are you still persisting with that?
Milady, may I clarify our position on that? Yeah. And this has been communicated to the State Attorney last week. It is an issue. What we have said is that we are not pressing the public participation element. We are dealing with procedural irregularity of the original Act, but not public participation as under Section 172 of the Constitution, etc. So we are not dealing with that in this court.
You're not going to be persisting with it in this court?
Yes, in this court. Thank you.
I just want to echo, the manner in which this matter has been dealt with leaves much to be desired. We've been given paper after paper to read. Out of expected a joint minute, practice note indicating to us what we don't need to read, given that there is duplication of documents and judgments in these files. So we find ourselves going through it, coming across the same judgment, the same annexures, and having to work our way through it. In a matter of this magnitude, a joint minute indicating what must be read and what shouldn't be read would have been helpful.
Thank you.
It doesn't help that you tell the State Attorney you're not persisting with it, and you don't tell us, because we would not have gone into that issue or prepared on that issue or read up on that issue had we known you're not persisting with it.
Because the court is not an important player, as it seems, the way we've dealt with it.
Milady and my Lord, the query came last week from Parliament. We
Mr.
informed
Moskowitz,
Parliament
if you had time to inform the State Attorney, you had time to inform us.
No, naturally. Milady, that issue, I apologize, firstly, of course, it doesn't affect any of the relief that we seek, but it does affect this scope of argument. Milady, if I can just go, I don't want to I want to cover the whole of the notice of motion. It won't take me long.
Yeah, but ask me then to deal with the notice of motion.
Yes.
Because I've got a few questions for you.
Yes, my Lord, Milady's Section 22 of the Act, report to Parliament.
First or pre?
Pre-first, please. So, 22, report to Parliament. 22.1 A and B and C has all the reports that must be submitted by the Commission, and we say that this is the other side. This is like the flip side of the report. The IEC receives the report, and then they need to report back to Parliament on it, and then to the wider public. And we say the same deficiencies in reporting to them are then replicated in their reports to Parliament and the public. And we say that should be rectified insofar as we are successful with broadening the the issue about threshold or the upper limits or the expenditure, all of that would need to be captured in a report to Parliament. Because
this whole section said unconstitutional.
to the extent that it depends on how far you go on the substantive issue.
It says the whole section 22
Correct.
is to be declared unconstitutional.
That's right. And we suspend, there's a suspension of, so later on we say the declaration should be suspended to allow Parliament to rectify, to ensure, and in the meantime it will have, the original section will be in force, but it will know from your judgment what they must rectify, which of the aspects. So yes, section 22, there isn't a specific subsection that one can identify where the deficiency arises, because they could put it into another subsection or they could put it into an existing subsection. It's just
So the suspension only relates to the declarations.
of certain
No.
declarations.
In the notice of motion.
Yes, correct.
And what about the other orders?
I'll come to those now. May I
Let's deal
proceed?
with it now.
Yes. No, absolutely. We are dealing with them.
So-
So I've done paragraph 1.
No, you've done paragraph 1.
Yes, and then paragraph 2.
And paragraph 2 deals with section 27.9G, 29H
Yes.
of EMAA,
Yes, my lord.
and it's the same legal basis.
Yes, except, if I may just, you are correct, my lord, except 27, section 27, that introduces a new sub-regulation 5, which creates a lacuna, effectively. So it's subsection 5. It inserts subsection 24.5, which creates a lacuna. So it's over and above our sections above. That's all. That's the main reason why it's that particular prayer. My lord, I'm moving now to the ones I think that you wanted to discuss, which is 3. Firstly, so 3.1 deals with the ongoing failure by the President under the new Act. And this is only to the extent necessary, because if we are successful in setting aside EMAA, then it goes back to the PPFA, where there's a 100,000 rand limit, 15 million rand limit, and no presidential involvement. This is only in the event that EMAA is still extant in some way. If it's extant, then to that extent, in 3.1, we say that President and Parliament have failed. When I said Parliament, I meant National Assembly. The President and the National Assembly have failed to take the steps that are required of them under the EMAA, which is to determine first of all, to pass a resolution, and secondly, determine the limit. But this is only if this court says that the President can be involved. If he can't be involved, this is plus petitio. But it's not. But we are catering for that as an alternative. And we say we've had the legislation since 8 May 2024. They have not to date, as we stand here, they have not determined the amount. And that would have created, but for the Tulare J judgment, that would have created the lacuna. And that is unacceptable, we say, from a my vote counts
But
2
that's been
perspective.
covered now in the interim.
But it doesn't excuse their lack of passing the regulation. They are required to pass the regulation, and their failure to do so is still a breach, and it continues to be a breach under EMAA. And in this regard, if I may ask the court to have regard to pharmaceutical manufacturers, this is a case where President Mandela had failed to promulgate the regulations which were necessary for a primary piece of legislation. And what the Constitutional Court said there, that's fundamentally irrational. You can't not do that. You must have the regulations ready when the Act is ready to come into force. And they didn't have that ready yet. It wasn't ready, and it's not ready 9 months later. And that's a breach that's unacceptable, and that's the reason why this relief is sought. And then 3.2 is to cater for the situation that Tulare J judgment is only an interim order pending this court's ruling. And therefore, going forward, there would need to be, if the EMAA has any life, you would need to have some thresholds and upper limits applicable. So we are effectively asking for a continuation of the Tulare J judgment if the order is to send it back to Parliament to fix it, but EMAA still exists.
So isn't it pending this court's determination by Parliament, whichever is earliest? That's not what the order
Yes, no, quite correct. And that hasn't happened, of course, as we know. And if Parliament does make that determination, then had it made that determination in the last 9 months, Tulare J judgment would have fallen away. The interim relief. My Lord and ladies. Yes, then 4, this is a consequential relief. This is part of the just and equitable under Hoërskool Ermelo and other judgments of the Constitutional Court. The Constitutional Court has made it very clear that irrespective of the declaration of invalidity, this court has can order just and equitable relief. And that just and equitable relief can be any relief. The Gajima case says just and equitable means effectively that the court is only bounded by considerations of justice and equity, whatever that means. And so what we are seeking is consequential relief, saying for those parties who have taken advantage of the lacuna must pay back whatever is above the 15 million rand threshold, and they must also disclose anything above the 100,000 rand. So this is all on the thesis that EMAA is still in
And how will the court enforce its order? How will the court enforce that order, especially if the enforcement? Remember, we don't have the individual parties join, and the parties doesn't want to argue at that point. It doesn't mean we can't take it into account. How can we issue that order if we cannot enforce it ourselves?
Yes, my Lord, it's a very important point. As with any...
No, you've asked for the order, so tell me, how
Yes.
do you want us to deal with it?
Yes.
And you didn't ask for an amendment this morning. So
No,
tell me
this is
why
been-
you're entitled to that relief
Yes.
for us to issue an order that it's in a vacuum because we cannot enforce it as a court.
My Lord, it's not, I submit that it's not in a vacuum. This is an order, this kind of order is just a consequential order. The order of invalidity
Do we know
declares
which,
invalid.
just a minute,
Yes.
listen to me. Do we know which donations you refer to in the third and fourth words of Prayer 4? Do we know?
My Lord, we do not have evidence.
Do we know who were the receivers?
They would be the political parties.
Could be.
Which ones?
Yes, no, I take the
And
point absolutely.
It's political parties,
Yes.
and it says and, it's not and or.
Yes,
So English is not my first language.
yes.
Is there a difference?
So in 4, in paragraph 4.
Yeah. Because it just says political parties and independent candidates.
Yes.
But let's accept my English is not so good. Or made by any person we don't know, or any entity or any political party, or from the date, forget about the numbers. So we must direct that all of that shall be paid back by such political parties and independent candidates to the relevant donors.
Yes.
Now, how is that order ever enforceable by a court?
My Lord, I submit that the order would be enforceable. What my Lord is saying is you don't want to grant an order where you don't know what donations have been made. That's essentially.
We don't know against whom we make the order, who are the beneficiaries of our order, what the circumstances were. Because, remember, you saying all donations.
Yes.
If you go and have a look at the definitions of donations, it's the straightforward ones, and there are qualifications, etc. Courts can only make orders that's enforceable and makes sense. Don't make orders in a vacuum. And if a court grants orders that you cannot enforce, then we're making fools of ourselves, as some counsel sometimes think we are.
My Lord, I am absolutely not suggesting that. May I just may I make submission in relation to what the thrust of these orders are? We say they're consequential on the declarations of invalidity, because once you declare it invalid, it's invalid ex tunc, and therefore anything done that was contrary to the original PPFA in the interim would be unlawful.
You see, under all the legislation so far, there's always a report to the IEC, ultimately. The IEC is not a party.
It is a party. It was cited as a party. It didn't decide not
Did you
to.
ask any relief against?
Well, we sought the relief that we did. Yet.
Did you seek any specific relief against the IEC?
My Lord, yes.
Because the IEC could be provide this information.
Yes, my Lord, and that's what we're seeking, is that to change Section 22, I've taken my Lord to, and Sections 12, where the reporting is made to IEC, and for the IEC then to report it to Parliament. That's the reason why we inserted those prayers. So we do seek that relief, but
it would not assist with prayers 3 and 4, or rather prayers 4, because we would not know.
I take that point entirely. No, I think it's a separate point. I think IEC, we do seek prayers in respect to the IEC.
Where on the papers are you saying that you're seeking that relief against the IEC? Anywhere on the papers?
So section...
Anywhere on the papers before us where you say you asking the IEC to provide certain information?
And that's the reason why we're challenging Section 22, because they provide that information to Parliament. That's the very nub of our Section 22
You're not
challenge.
seeking that on the papers. In fact, when you deal with the IEC in paragraph 12, page 13 of the paginated papers, I don't know what the original file looked like. I'm talking about these loose papers that we're getting to work from. You say you're merely citing them because they have an interest in the matter.
Yes.
You're not saying you're seeking any relief from them or against them.
My Lord, there are two different issues. Obviously, if there is a difference in the disclosure threshold...
If you do seek for them to do anything, then there's a misjoinder.
Non-joint.
A non-joinder.
Yes.
Sorry.
My Lord,
My
sorry.
English.
Sorry, my Lord, if I may, I just wanted to clarify. We seek as our principal relief, the relief that I've taken the court through in relation to Section 8 and 9 and Regulation 7 and 9, plus Section 12 and Section 22 and 24. Those deal with the full chain of disclosure and upper limits.
But your relief in respect of Section 22 is you want to declare it unconstitutional.
To be sent back.
To be sent back. That doesn't address the fact that you're not asking the IEC to provide any report to you or any information in respect of donors or donations that were received.
Yes.
So your relief in respect of Section 22 does not really assist you.
Well, Section 22 will assist when it's sent back, because part of our...
Sorry, Mr. Mosevich, it won't assist in relation to the relief set out in
3 and 4. Yes, no.
At this moment.
That's why I said those two must be distinguished. Our Section 22 is not to support 3 4 or 5. It's not to support those prayers. So my Lord and my Lady are correct in that regard. Section 22 is just a consequential prayer to set aside Section 22 is consequential on our main argument that there has to be broader disclosure. And obviously, once it's disclosed to the IEC must disclose it further. That's to be dealt with by Parliament, and that would be consequential. That would not be controversial if the principled issue is found. 4 and 5 deal with a different issue. They deal with the issue of what to do in the interim period. That's the only thing. And if this court is not comfortable in ordering that as against parties who are not currently before it, I understand that. And I understand that I've made my submissions in relation to why it's there. We say that that follows by virtue of Ferreira versus Levine inexorably because you have extreme constitutionality in validity. But it could be a Simelane situation where not every decision taken by Mr. Simelane was impugned in the interim, even though he was unlawfully appointed. I take the point completely.
It's more a case of incompetence, that the release order is incompetent, not that it's due to a sense of discomfort on our part, that it's not competent.
Yes, I'm saying I submit it is competent as part of just and equitable relief of the court of wrong. That's my submission. If the court doesn't want to go that far, or wants to say it's only limited to the parties that are before it, I understand the court's, what the court is putting to me. I've made my submission. I can't take it further. If I may go on to the next, very quickly. I'm essentially out of time, my lord and ladies, and I am almost done. I'm at the end of my address. So, paragraph 6. All we are saying is it's the declaring the PPFA pre-amendment and then post-amendment EMA unconstitutional for the reasons set out in our founding papers. And this is the kind of relief, if I may just say, this is the type of relief that was granted in Glenister. So it was a broad relief where they said it's to the extent that it's unconstitutional. So this is not unprecedented, this kind of relief. And
Can I just ask you the question
yes.
that I should have asked you this morning? Why do you distinguish and call it the EMA?
My Lord,
I'm just thinking of how we're going to write it up in the judge. And I wanted to ask you early this morning.
yes. My Lord, because these are amended papers, we've amended it to reflect the changing reality.
No.
What's happened in the interim?
You see,
Yes.
when did the amendment take place?
8 May 2020.
No, the amendment of your papers.
7 June, or June. It was later in June. It was the intention to amend 7 June, affecting amendment later in June.
And when did the EMMA, those provisions that amended the PPFA and at the same time changed the PPFA's name to the PFA, when did that come into operation?
8 May 2024.
So why do you still refer to it as EMAA in June and July?
Because we attack
And here now.
Sorry.
No, because it's now under the PFA.
But we say it reverts back. So if we are right about our unconstitutionality argument on EMAA, then it reverts to the PPFA in its original form. That's the reason why we refer to it.
Is that why you're going
Between the two buildings. Yes,
to
Mr.
Wellington by Worcester?
Yes, but we have to do that for the purposes of the logic.
No, I can understand
Yes.
for argument's sake.
Yes.
I'm talking about
And we submit that it's...
in the notice of motion,
Yes,
you seek certain declarations
yes.
with a particular name of the man. But we know that name has changed. The PPFA, that name changed to the PFA. And it was changed by the EMAA.
Yes. Yes. So just to maybe to explain, if you go to prayer 1, Lord, where we say declaring certain sections unconstitutional. We say either as amended, in its form as amended, or in their pre-amendment form. We're trying to cater for both situations. I agree, my lord, with the nomenclature. It should have said PPFA, alternatively PFA, effectively.
I'm asking you this not just to be difficult.
Yes.
We're asking for declarations of unconstitutionality of legislation. We need to be precise.
Yes. My lord, the sections are the same.
Doesn't matter.
No, I know.
Yeah.
My lord, I take on point the nomenclature. I agree. But it's the purpose and the import, I submit, is clear as to what we try to achieve. And I've explained how we try to achieve it. If I may, I'm done with the notice of motion, and I'm done with the legislation. I just want to mop up 2 or 3 points that were raised by your lordship, and by and a couple of other points that were raised in argument. It's the first relates to paragraphs 155 and 156 of my vote counts 1. That's an issue that was raised by my lord presiding, and the issue there. So it's a very important point in the sense that my vote counts 1 is the genesis of this whole series of litigation. That there's a majority judgment, minority judgment. The majority judgment effectively said that it's for Parliament to decide on the course of action as to whether it wants to amend PIA, not amend PIA, what it might want to do, and there's a lot of latitude that's given to Parliament in general. We do not what the case that was said in the context where the Constitutional Court found that because Parliament has passed PIA, we had to launch, as my vote counts, a frontal challenge to its provisions. That's the context within which they made that ruling. And they said, well, Parliament has said it has passed the legislation, so we have to attack that legislation. Then we went back in 2017 before MIAJ, and then my vote counts 2 in the Constitutional Court, arguing in relation to PIA frontal challenge. What's important is that 155 and 156 in no way restricted us from doing that, because
No, just a comment made by the court, by the majority in the Constitutional Court.
yes,
That's why I took it.
Yes.
I have a follow-up question, but
yes, my lord, that does not in any way detract from our challenge before this court now, because just like in Glenister, so if I may give an example of Glenister, and there are parallels. In Glenister, the Hawks legislation, which was the South African Police Services Amendment Act, was passed pursuant to the Polokwane Resolution in 2007. 2008, they passed the legislation. There was Mr. Glenister, Hugh Glenister, launched proceedings out of this court. He was blown in this court on irrationality challenge. When it got of that legislation, when it got to the Constitutional Court in 2010, Helen Suzman Foundation came in as an amicus and raised not only the irrationality challenge, but the challenge in respect of Convention Against Corruption and other things. Pursuant to that case, the court declared the whole chapter unconstitutional in 2011, on the 17th of March 2011. It then once it declared it unconstitutional, it went back to Parliament. Parliament then went away and tried to fix the issues that the judgment identified. It identified issues in the course of the judgment, not in the order. It said it doesn't provide for adequate independence. It then sent it to Parliament. Parliament then did its job for a year and a half, 2 years. It was still inadequate according to the Helen Suzman Foundation. The HSF then launched proceedings out of this court to challenge that new legislation because it was contended that it didn't meet the standards.
Why do you refer to the HSF as we?
We represented HSF in that investigation. So HSF, HSF then launched proceedings out of this court, also complaining about various sections that were unconstitutional. And that made its way all the way up to the Constitutional Court, and it upheld that challenge, almost in its totality. So it's not, what we are doing here is not atypical. What the Constitutional Court, in my vote counts to, said, fire is inadequate. Parliament, yes, can fix it in any way that it wants. These are the standards. These are the key issues that you must deal with. It sent it back. What they did, we say, is inadequate. We are coming here to challenge the sections that they have inadequately dealt with. We say it doesn't give effect to my vote counts to, but we have a broader challenge that goes beyond my vote counts to. And that's why we're here, and that's the nature of our challenge.
So your challenge goes back to the PPF.
And the PFA. Yeah. Amended and unamended form. Absolutely. We need to cater for changing circumstances, my lord. So that's why we made provision for it in our notice of motion. But what I wanted to say is that that's not an unusual situation, and we challenge it both on the basis of rationality, just like was done in the Glenister cases, and on the basis of unconstitutionality because of a breach of rights. And we are entitled to do that, we say, and we submit that we are correct in our analysis of the legislation, and then it falls to be set aside in the manner that we intend. So, my lord and my ladies, that brings to a conclusion what I wanted to submit to this court in respect of our challenge. I just wanted, on the costs, we say buy-wash applies. The DA says it doesn't apply to them. They are wrong. We'll deal with it in reply if I have to. I'm not going to deal with that issue for now. Unless there are any other questions.
No, we'll hear you in reply.
Yes, thank you very much. Thank you.
Thank you, Ms. Pillay. For the 20th and 21st, it's a short.
Thank you.
And we've read your aids.
Thank you very much. Members of the court, it is one of these rare occasions where I can genuinely say I'll be brief. I have no intention of only running about 10 minutes. Justices, in the course of my address, I intend addressing three issues. First, the relief that's been sought against Parliament. Second, why each of the two challenges against Parliament must fail. And thirdly, the issue of costs. Now, members of the court, you will be aware that this matter has a somewhat strange history when it comes to Parliament. The initial challenge was launched, relief was sought, no direct relief was sought against Parliament, and Parliament was not cited as a respondent on the occasion. The proceedings then went ahead before Justice Tulare. Attendant on that, their supplementary papers and amended relief sought. Parliament had to fight relatively hard to be here, and that was the result of an order ultimately taken by agreement before the then acting Judge President. Justices, members of the court, there are then perhaps two unique features about this case. The first is what it seeks to vindicate are inconsistent with elementary principles of law. I don't make that submission lightly, but I do it in the context of what's being sought as against Parliament. And I say that for two reasons. Firstly, when there's a material disjuncture between the relief sought against Parliament and the case made out in the supplementary Parliament. And the court will see that there's relief sought, and I'm going to go to the amended notice of motion in a moment, relief sought in paragraph 6 of the amended notice of motion, where it's not clearly sought, but it really goes to the heart of the public participation process. The court will see that there's relief sought against Parliament in prayer 3.1 of the amended motion. And again, the court need not go there, I'll go there in a moment. But the relief that's sought against Parliament really does not feature in the founding affidavit. So that's the first irony. There's no correlation between the case made out and the relief sought. The second, Justices, is that there's an inherent contradiction in respect of the standard to which Parliament is sought to be held in this matter. On the one hand, there's a complaint that Parliament has not acted forthwith or promptly in doing what it ought to have, and on the other, there's a complaint that there's been an inadequate public participation process. The applicants can't have it both ways. Public participation processes and legitimacy and credibility of state decisions of necessity take time. And it's unhelpful to come to court and complain that it's too long on the one hand and it's not prompt enough on the other. So Justices, against that backdrop, let me then turn to the first of the issues that I had intended dealing with, and that is the question of the relief sought in this. And I prefer to work from the notice of motion, which appears at page 612 of the papers.
The black and white.
Sorry?
The black and white.
The black and white one, thank you. And the court will see there's effectively reference to Parliament in two respects. The first is at prayer 3.1, and it's only the second half of that prayer which appears at the top of page 613 of the papers. And the court will see that what sought is an order that the failure by the National Assembly forthwith, after the enactment of the Amendment Act, to enable the President to do so is irrational, unlawful, unconstitutional, and invalid. So that, Justices, is where there's express and direct reference made to Parliament, and our learned friends have submitted that that is the relief they seek to assist with. The second is at page 614, paragraph 6 of the amended notice of motion. And there's no express reference to Parliament there, but as we see it, the import of that order, when looked at against the NA, is to say if there's been a defective or inadequate public participation process as foregrounded in the founding affidavit or in the supplementary founding affidavit, then the declaratory relief in the terms sought therein ought to go, ought to be granted. And I accept that in line with Glenister, this is a broad framing of the relief. I identify its target only in relation to Parliament.
How do you understand the relief sought against your client with the last alternative?
Which one?
The last alternative in the prayer. How does one defend yourself against such relief?
Yes. So Justices, as I understand a relief in those terms, often what happens is, of course, as the court is well appraised, there's a suspension, there's an interim order that's put in place, and we see more and more there's court orders catering for an eventuality if certain things are not done. But that, Justice Erasmus, for the moment I won't deal with. If I get to the Constitutional Court, I will. Members of the Court, if I could then take you to the first challenge, which is the inadequate public participation argument. And we submit that it must fail for three reasons. I'm not going to go into any of that within the jurisdiction point. The first is it falls within the exclusive purview of the Constitutional Court's jurisdiction, and that ought to be the end of the matter. The second is in any event, it's a badly brought challenge. The court will have regard to the papers at 433, paragraph 77, and 411, paragraph 7.3. There's simply no factual basis for the challenge.
Page 433, paragraph 77, and page
411, paragraph 7.3. And the last, members of the court, is in any event, it doesn't withstand scrutiny on the facts, and the court just need have regard to Parliament's affidavit at page 765 and 5. But there's a more fundamental problem for our learned friends in regard to the public participation movement, and that's this. The challenge was raised in the supplementary funding affidavit. Parliament and the other parties pointedly raised the issue of jurisdiction, exclusive jurisdiction. Yet our learned friends persisted in filing its argument in which it was not dealt with at all. There was no indication given that it was abandoned, that it was withdrawn, that it was not persisted. In the circumstances, Parliament filed heads of argument dealing with the issue, and correspondence was then exchanged where the applicant's position was clarified in correspondence to Parliament. So for those reasons, members of the court, we said...
At least you knew.
I'm sorry?
At least you knew. We had to crawl through it on the weekend.
With a little bit of probing, and I apologize from our side too that the court wasn't effective place with it. So that's the difficulties with the public participation order, and for that reason, insofar as Prayer 6 seeks to strike against the public participation argument, it must fail. Members of the court, the second leg of the applicant's challenge then is that foreshadowed in Prayer 3.1. And we submit that that challenge must fail both at the level of law and at the level of fact. At the level of law, if the court has regard to the wording as it appears at 613, it's a failure by the National Assembly forthwith after the enactment of the Amendment Act to adopt the resolution. So of course at the level of law, what the applicants must succeed in demonstrating to this court is that there is a duty in the Amendment Act for the NA, and there's a good word, forthwith to adopt the resolution. And absent a proper construction of that act that places such a duty on the NA, we submit that the relief sought in Prayer 3.1 doesn't get off the starting blocks. I'm going to ask the court to go to section 24. It's in the court's bundle at paginated page 23.
Just repeat that, please.
Sorry, page 23 of the court's bundle of the party, section 23.
Simply because
Of the respondent's bundle.
Sorry, this is the authority.
The authorities. Thank you. So in 24.1a says the President, acting on a resolution of the National Assembly, may, by proclamation in the Gazette, make regulations in those terms. And the court will look long and hard as to where to source an obligation on the NA to forthwith adopt a resolution. And let me not be misunderstood. I accept there's a need for reasonable swiftness and promptitude in agendas, like my submissions are directed at the specific order in the terms as sought. And so, absent a legislative basis for an order in those terms, we submit that order to be the end of the relief sought against the NA in Prayer 3.1 of the amended notice of motion. But secondly, Justices, the problem is more fundamental on the facts. And that is because, bearing in mind, the applicant's case isn't that the NA failed to act with reasonable promptitude, it failed to act sufficiently quickly in the matter, it is that it failed to act forthwith. And when the court looks at that, it would look then at the position taken or at the timeline. And members of the court, the timeline is this. The Amendment Act, as appears from page 775, came into operation on the 8th of May 2024. The court will be aware that on the 9th of May, there was a resolution that was ultimately not carried. And that resolution on the 9th of May appears from Justice Tulare's judgment at page 594 of the papers. And it's explained there that ultimately that was not carried and the discussions did not take place on the 9th of May and were postponed to the week of 16 May. Justices, you will then be aware that what happened on 16 May appears from Annexure SA 17 at page 517. May I ask the court to go there, please?
Give me that page again.
570, Justice Erasmus.
Which bundles? Because there's not enough space here, so we have to juggle. No wonder he's thrown in a Dropbox. 57?
570, it's SA 17.
Yep.
And the court will then have regard to the order paper as it stood on the 16th of May and the draft resolution as proposed there. And it says that it notes that Section 24(1)A of the Act requires that the President act on a resolution of the National Assembly made by proclamation in Gazette, make regulations as contemplated in those sections.
Yes.
And the court will then be aware that in the period between the resolution...
It wasn't carried because Mr. Bishop's clients opposed it.
Not surprisingly so. Justice Erasmus, you would then be aware that in the period between the 9th and the 16th of May, there was the application, the urgent application, that was launched before Justice Tulare. And that appears as SA 16 at page 565. And that application was brought on the 10th of May. And the court will then be aware that Justice Tulare handed down judgment on from page 586. So, when engaging with a relief sought in prayer 3.1 of the amended notice of motion, the court will bear in mind this timeline. The Act's operational on the 8th of May. On the 9th of May, there's a resolution that's proposed that isn't carried. On the 10th of May, the urgent application is brought. On the 16th of May, the second resolution goes before Parliament, and on the 27th of May, the judgment is handed down, regulating the interim position. And on that analysis, members of the court, we submit A, there's no basis for reference to a declaratory order in the terms sought, and B, by the National Assembly.
Did they rise on that day? So there were lots of farewell speeches
There are lots
on
of
the
farewell
program.
speeches. Justices, I want to be cautious to stay in my lane in these submissions, but I do want to make perhaps this point, and that is Parliament's position attendant on the order and judgment of Justice Chilare. And if I may ask the Court to have regard to page 778 of the papers. And the Court will note at paragraph 52, Parliament says the NA took the view that in adopting the May resolution, i.e. the 16 May resolution, it had done what was required of it in terms of Section 24 of the Act. It then explains, members of the Court, at paragraph 55 and following, that subsequent to the judgment of the Western Cape High Court, Parliament was advised to reconsider its resolution and to pass a resolution that contained the parameters and threshold. Reference is made to the minute of the MA programme there, and it stated that it was agreed that members would be furnished with a briefing note and the May resolution in preparation for a new resolution. The briefing note appears at ATV 13 and it's quoted at page 779. And in that briefing note, Parliament was told that for the new resolution to be constitutionally compliant, it must indicate specific amounts for the upper limit and the disclosure threshold. The President will then be empowered to make regulations based on the resolution of the National Assembly. And the process is then dealt with there. So whether the applicants think otherwise or not, the point, the submission is that there's a particular interpretation that's been given to the Act. Parliament was guided by the judgment of Justice Chilare in adopting that interpretation, and if one has regard to the timeline in how it sought to execute it, there can be no complaints of undue delay, failing to have acted with the requisite promptitude, etc. And the threshold of needing to forthwith do it is simply not borne out in the legislative scheme. Members of the Court, if I could then deal with the last issue, and that is the question of costs. I don't do this lightly when I act for the state, but this is one of those cases where I do make this submission. And that is that BioWatch doesn't afford litigants to litigate against the state on a blank check basis. There are parameters to BioWatch, and this Court is aware of what Justice Sachs said at paragraph 24 of the BioWatch judgment, where he said, at the same time, however, the general approach of this Court, 24. The general approach of this Court to costs in litigation between private parties and the state is not unqualified. If an application is frivolous or vexatious, or in any other way manifesting inappropriate, the applicant should not expect that the worthiness of its cause will immunize it against an adverse costs order. And the Court is well apprised that those principles found its way into the Constitutional Court judgment in Lawyers for Human Rights. That's 2017, Volume 1 SA, 645, Constitutional Court, at paragraphs 23 to 27. And so in conclusion, members of the Court, I end where I started, and that is, this is a manifestly inappropriate case for the applicants to receive the protection of BioWatch. They've come to court certainly against Parliament, where they seek relief that's not foreshadowed in the founding affidavit. Conversely, they make allegations in the founding affidavit that doesn't find its way into distinct relief in the notice of motion. I mean no disrespect when I say the application doesn't get off the starting blocks. And for that reason alone, it ought to be one of those cases where the caveat in paragraph 24 of Firewatch funds application and a cost order is made against the applicant. The court would be with me for a moment. I'm told I'm covered. Thank you very much for your support.
Do you want to start, Mr. Maniki, or it's 3:20, rather should we not?
I'm in the court's hands, but it would be much more convenient to start in the morning. But
I think we do that. We've made up some time in the evening to shorter lunch. And then we can push tomorrow. Hopefully we can fix the aircon. Unfortunately, the other bigger courts, the place for council is not that comfortable as yet. But we'll see what we can try and achieve overnight.
maybe we can see how exchange comfort for cooler coffee.
But that's what I thought we could do, but I'm thinking the only ones will be called 21, 22 on this side, where the aircon is working right. But there's not much accommodation for council to sit and make those benches will be very bad for council. So let's see what we can do overnight from our side, and then we can start at 10 tomorrow morning.
I mean, that's the vote.
Whilst the red light is on, the microphone is alive. So it's recording. Ensure that you switch off so that the council can engage freely.
We went.